Hello and welcome. This is part 4 of the memorandum in support of the petition for the writ of habeas corpus. Again, this is Karen Reed versus Norfolk County Superior Court and the State Attorney General of Massachusetts. The hearing for this writ of habeas corpus is scheduled for next Wednesday, March 5th, 2025. I may or may not be in attendance. We'll just see how it goes. I'm available that day to appear in person, but I know there's going to be a large crowd there in attendance, and my hope would be to get a seat inside the federal courtroom to witness the hearing in person, but that tends to be difficult. I have found when I've gone to standouts in the past, it's very difficult to get in the courtroom because of it's a first come, first serve basis, unless you are like welcomed in by the family or by the defense team or by the press, or if you are yourself a member of the press. So we will see. But if I'm able to attend next Wednesday, March 5th, I will certainly make a video with all the photographs I take and any videos I take. So we will see how that goes. So again, this is part 4. I will leave the links to part 1, 2, and 3 in the description below. I will also leave Karen Reed's defense fund links to her Venmo and her PayPal in the description below if anyone would like to donate to her defense fund. And in part 3, we were around page 22, but I want to read the last sentence of page 21 so that we're more familiar with where we were. I also want to say that, again, I think I specified it in part 1. This entire document is 700 pages long. The portion I am reading is the memorandum, but the actual writ of habeas corpus, the actual appeal, is 700 pages long, and I doubt I will be able to read all those pages before the hearing on Wednesday. But my hope is to finish the memorandum at least, and the memorandum is 35 pages. So I plan to finish the memorandum in part 4. So I will try not to provide too much commentary. It's very difficult when I get triggered and I need to vent, but hopefully part 4 will contain less commentary so that we can actually finish the memorandum. So page 21, the last sentence reads, contrary to the SJC's suggestion, see opinion at 1920, there is simply nothing coercive about asking a jury whether it has reached a verdict on some, but not all separately charged counts. Provides a case law, United States versus Armstead. Now we're on page 22. And in parentheses, the portion they're citing from the case law reads, affirming instruction that, quote, simply asked the jury to report any partial verdict it had already reached, end quote, as non-coercive. And provides another case law, United States versus Kachengo. And in parentheses, quote, a court does not err if it asks about a partial verdict, even when it is clear that the jury is at an impasse and further deliberations would prove fruitless, end quote. Pulling away from the memorandum, that citation directly applies to what happened during the first trial when Judge Bev declared that mistrial. I will read the sentence again, quote, a court does not err if it asks about a partial verdict, even when it is clear that the jury is at an impasse and further deliberations would prove fruitless, end quote. Excellent citation. And again, it directly applies to what happened. If Judge Bev simply asked about any verdicts, if she simply followed Rule 27B, we would not still be talking about this case. Highly unlikely, with the exception of count 2, maybe count 2 would have been enough to do a retrial. But anyway, continuing, guys. Also at the end of the last sentence is number 8 for a footnote. I will read that when we get to the bottom. It continues, moreover, the trial court could have alternatively A, informed the jury that it could not be required to continue deliberations without its consent, and still B, asked it to retire to consider whether it was prepared to return any partial verdict. Provides a case law, Commonwealth versus Jenkins. This Massachusetts statute, on its face, by permitting the jury to be sent back to continue deliberating with its consent, contemplates that courts may non-coercively make a post-Tui Rodriguez inquiry to the jury as to whether it consents to continuing deliberations on all or less than all charges. Excellent point. Good job, defense team. Continuing, whether the trial court would have ultimately adopted any of these alternatives is beside the point. The dispositive fact for present purposes is that the record provides no indication that the trial court even considered available alternatives. Excellent. The last sentence, pulling away from the memorandum, the last sentence is saying the dispositive fact for present purposes, for right now, is that the court record that we all know provides no indication that Judge Bev even considered available alternatives to the mistrial. Excellent sentence. And there's another footnote, number 9. So we will read footnote number 8. It reads, Bluford held that before declaring a mistrial, the trial court was not required to permit the jury to return a partial verdict on lesser included offenses within a single charge. The Supreme Court explained that, quote, under Arkansas law, the jury's options were limited to 2, either conviction on one of the offenses or acquit on all, end quote. Commonwealth versus Roth. A case relied upon by the SJC also involved lesser included offenses within a single count, but by contrast, whereas here, quote, a complaint or indictment in multiple counts charges multiple crimes, end quote, a partial verdict is an available alternative under Massachusetts law. Provides a case law, Juvenile versus Commonwealth. See also Roth, and in parentheses, distinguishing situation, quote, where a defendant has been charged in separate indictments of complaints, each with a separate verdict slip, end quote. And again, entirely applicable to Karen Reed's situation. The next footnote is number 9. As stated, supra page 15, the federal constitutional burden to justify a mistrial is clearly on the Commonwealth, yet the state court not only failed to identify that burden, but improperly placed the burden on the defendant on subjects such as the consideration of alternatives. Excellent argument by the defense, guys. Excellent argument by the defense. Yes, that it lies on the prosecution. The burden lies on the prosecution, yet Judge Bev not only failed to identify that burden as being the prosecution's burden, but she also improperly placed the burden on the defendant. She improperly placed the burden on Karen Reed. And as I said in my last video that I uploaded yesterday about the Karen Reed supporters' reaction, their response to the hearing just a couple days ago that occurred on Tuesday. Judge Bev has treated Karen Reed as if she did it, as if she was guilty. Judge Bev has treated the defense and Karen Reed as if they are in the wrong, and it's the prosecution who's right. You know, the burden is supposed to be on the prosecution, but Judge Bev has, and she continues to put the burden on the defense. It is not right what we are all witnessing here, guys. I have lost all patience for Judge Bev. I really have. You know, what is that band with that song? Can't You See? What is it? Traffic Band? Yeah, listen to that song, because that woman, can't you see what that woman been doing to me? Yeah, that's Judge Bev. She's a black widow, for sure. She's no good. Continuing with the memorandum, we are on page 23. While the law is clear that a jury deadlock may constitute manifest necessity, quote, the key to this principle, of course, is that the jury must be genuinely deadlocked, end quote, provides the case law. Here it is possible to read the jury notes in the context of the trial court's instructions as reflecting an impasse on one but not others. The jury's reference to, quote, charges, end quote, is easily reconciled with the post-trial affidavits affirming that the only deadlock related to the lesser included offenses of count 2. Indeed, the trial court repeatedly referred to those lesser included offenses as distinct and multiple, quote, charges, end quote, both in its initial and supplemental instructions to the jury. And they are citing, I believe, a transcript. Yeah, the transcript from the June 25, 2024. It continues, in this context, the jury's final note was facially susceptible to two alternative interpretations. One, that the jury had reached an impasse as to all charges, or two, that the deadlock applied to only some of those charges, in parentheses, multiple lesser included allegations with a single count such as count 2. It was not an unambiguous note affirmatively declaring an impasse on all charges as assumed by the Supreme Judicial Court. Excellent. I'm going to read that sentence again, guys. It was not an unambiguous note affirmatively declaring an impasse on all charges as assumed by the Supreme Court. And they most certainly assumed, guys. As I said, I scrutinized them. They only copied and pasted Judge Bev's arguments, and they did not provide any discernment of their own. They did not provide any oversight of their own, even though it is their job. They had one job, and their job as the Supreme Court is to provide oversight, and they clearly did not. Continuing. The information received from jurors post-trial proves that latter interpretation was correct. Exactly, pulling away. Like, just listen to the jury members. Just listen to them. Don't define it the way you want to define it. Listen to the jury members, Supreme Court and Judge Bev and prosecution. Continuing. The jury's failure to expressly mention its agreement on counts 1 and 3 is understandable in light of the court's instruction that it, quote, should continue deliberating until it had reached a final verdict on each charge, end quote. And pulling away, someone left a comment on one of my videos talking about that exact point, that the instructions the jury members were given by Judge Bev were themselves likely interpreted literally by jury members who did not know any better. And again, that's a failure on Judge Bev's part. It's not Karen Reed's fault. It's entirely on Judge Bev. Continuing. For these reasons, the SJC was wrong to characterize the juror affidavits underlying the defense motion as, quote, inconsistent, end quote, with the jury notes. Amen. Amen. I'm going to read that again. For these reasons, the Supreme Court was wrong to characterize the jury affidavits underlying the defense motion as, quote, inconsistent with the jury notes. Like, what the hell are you talking about, Supreme Court? Did you not see the jury affidavits? Did you not see that the jury reached out to the defense and to the prosecution? What does it matter what the jury notes were? If they were clearly confused, they were clearly misled. I'm telling you guys, the Supreme Court is in on it. You know, I really tried to give them the benefit of the doubt, but I don't trust them whatsoever. They have as much credibility as the Supreme Court and the prosecution, which is zero. Continuing. Opinion at 3 jury simply never stated that it was unable to, quote, reach a unanimous verdict on any of the charges, end quote. The SJC did not mention, much less analyze, the reading of the notes set forth by the defense above. Absolutely. Yep. Yeah. Again, the SJC showed us, they showed the world that they don't really give a damn. Continuing. The trial court, quote, took no steps to clarify the jury's, end quote, notes. Provides a case law. In the double jeopardy context where the Commonwealth alone bears the burden of establishing manifest necessity, this ambiguity must be read in the defendant's favor. And it's citing an attachment, quote, ambiguous verdicts must be construed in favor of the defendant, end quote. And the case law, Donham versus United States, quote, we resolve any doubt in favor of the liberty of the citizen rather than exercise what would be an unlimited, uncertain, and arbitrary judicial discretion, end quote. Excellent citation. Continuing, the SJC therefore erred in construing the jury notes as an unambiguous declaration of an impasse on all counts. Excellent job, defense team. And there's a footnote number 10. I will read it at the bottom of the page when we get there. It continues, quote, in sum, a decision made so precipitately could not have been the product of any careful consideration of the valued right of the defendant to have her guilt or innocence determined, end quote, in a single trial. This in itself precludes the Commonwealth from retrying Miss Reed on counts 1 and 3. Let's pray that the federal court agrees, guys. Let's pray that the federal court agrees. Guys, pulling away. Can you imagine, guys? The hearing is next Wednesday. Karen Reed's retrial is scheduled for April 1st. You know, that's why Hank Brennan and the rest of the prosecution and Judge Bev are throwing everything they can, you know, to discredit the defense and to discredit ARCA. You know, they're throwing everything at it to completely disqualify the defense and disqualify the ARCA experts. It's as if Judge Bev and the Commonwealth and Michael Morrissey and their political representatives, it's as if they all know that the federal court might have something different to say for once. And Karen Reed just might be acquitted before she's even retried. Yeah. I would love to manifest that. Just putting that out there in the universe. Okay, continuing. Letter D. the jury's unanimous conclusion following trial that Miss Reed is not guilty on counts 1 and 3 constitutes an acquittal and precludes re-prosecution. Quote, what constitutes an acquittal is not to be controlled by the form, end quote, of the action in question. Martinez versus Illinois. Quote, rather, the court must determine whether, end quote, the action, quote, actually represents a resolution, correct or not, of some or all of the factual elements of the offense charged, end quote. Excellent citation. I'm going to read this quote, and then I'll read the footnote. It's solid, guys. I've just been so discouraged, like, it's like the defense has supplied multiple solid motions in the past, concrete motions in the past. But because the corruption is so thick in this case, it's so often proven all for naught. It's so often proven futile. So it's like, I'm like so impressed by this memorandum so far. And I'm like, it's solid. It should be enough, it should be sufficient. But I've been let down so much in this case that I don't want to get my hopes up, Anyway, continuing, quote, labels, including those provided by state law, do not control the analysis, end quote. Excellent. And guys, the defense has made this argument multiple times, especially within the last year, especially during 2024, that you have to pay attention to the substance more so than the form. And so when the SJC doesn't consider this, and when the Supreme Court doesn't consider this, they are obsessing over the form and they are ignoring the jury members who were misled. I'm going to read this footnote at the bottom of page 24, number 10. In Commonwealth versus Daniels, the jury responded by a Tui Rodriguez charge by saying it had not reached a unanimous decision on any of the charges. The trial judge then asked counsel for his position, and counsel said he did not object to a mistrial. Daniels does not, therefore, support the SJC's finding that the trial court appropriately exercised its discretion here. In any event, Daniels does not bind this court in its analysis of the federal constitutional issue. Excellent for the defense to call the SJC on their fuck up. Their absolute fuck up. Again, no oversight coming from the Supreme Court in Suffolk County in Massachusetts. Zero oversight, even though the job of an appellate court is to be the oversight for the lower courts. They're wasting everyone's tax dollars. Continuing. We are on page 25. This is because, quote, whether an acquittal has occurred for purposes of the double jeopardy clause is a question of federal, not state, law, end quote. Excellent. Let's hope the federal court can handle it. Continuing. Here, the affidavits by attorneys Jackson and Yannetti reflect statements by 4 deliberating jurors that the jury had reached a final unanimous conclusion that Miss Reed is not guilty of counts 1 and 3. In parentheses, and an indirect statement by a 5th juror that they had agreed with respect to count 1. Both the trial court and the SJC, for purposes of ruling on the double jeopardy issue, quote, proceeded from the assumption that the affidavits were accurate, end quote. There was nothing tentative about the jurors' statements. To the contrary, they were definitive in describing the result of the jury's deliberations, provides affidavit of Alan Jackson. Quote, Juror A was emphatic that count 1, second-degree murder, was off the table, and that all 12 of the jurors were in agreement that she was not guilty of such crime, end quote. Affidavit of David R. Yannetti, in parentheses, reflecting text message from juror B, quote, "It was not guilty on second degree. No one thought she hit him on purpose or even knew that she had hit him," end quote. Reflecting juror C's statement relayed by intermediary C that there was, quote, "no consideration for murder too," end quote, and Miss Reed, quote, "should have been acquitted," end quote, on that count. Provides the supplemental affidavit of Alan Jackson. In parentheses, quote, "Juror D, without hesitation, said in substance, every one of us will agree and acknowledge that we found Karen Reed not guilty of counts 1 and 3, because that's what happened," end quote. Second supplemental affidavit of Alan J. Jackson. In parentheses, quote, "Juror E explained that the jury was unanimous on 1 and 3, that Karen Reed was not guilty of those charges," end quote, despite significant publicity that accompanied the filing of the defense motion relying on jury declarations. None of the remaining jurors ever communicated to the court's staff, the district attorney's office, defense counsel, or the media that they disputed the accuracy of the 5 jurors' representations. And pulling away from the memorandum, we are on page 26. And it still stands true today, guys, as of February 27, 2025. No juror from the first trial has come forward to say anything differently about those verdicts, meaning that, in fact, the jurors, it's reasonable to assume all 12 jurors agree that Karen Reed was found not guilty of counts 1 and 3. She was also found not guilty of count 2, but they were stuck on the lesser included charges. Continuing. In rejecting Miss Reed's claim of acquittal, the SJC relied solely upon the lack of a formal verdict, quote, "returned, received, and recorded in open court," end quote. This reasoning is rooted in a formalism that has been consistently rejected by the Supreme Court in a string of precedents spanning more than 100 years. You see that, guys? The defense team is calling the Supreme Court of Suffolk County old-fashioned, that they are so old, they are relying on logic that is outdated by a century, that no longer do courts obsess over the form. They actually look at the context. They look at the substance. You know, what happened? You know, yes, these are the rules in black and white, but what's the gray area? What actually happened despite the rules? Like, what did the jury members actually say happened with those verdicts? And it provides a case law, Ball versus United States, in parentheses, quote, "However, it may be in England, in this country, a verdict of acquittal, although not followed by any judgment, is a bar to a subsequent prosecution for the same offense," end quote. Hudson versus Louisiana, in parentheses, holding that judicial grant of new trial prohibited retrial on double jeopardy grounds, notwithstanding that the state, quote, "Code of Criminal Procedure did not authorize trial judges to enter judgments of acquittal in jury trials," end quote. Quote, "The double jeopardy clause prohibits re-examination of a court-decreed acquittal to the same extent if it prohibits re-examination of an acquittal by jury verdict, end quote, Smith versus Massachusetts. The Supreme Court has, for example, quote, consistently refused to rule that jeopardy for an offense continues after an acquittal, whether that acquittal is express or implied by a conviction on a lesser included offense, end quote. Price versus Georgia. And I will read this footnote, number 11. The SJC's reliance upon almost 90-year-old Supreme Court of Tennessee opinion, which has never been cited in any published federal court decision, is unpersuasive in light of the foregoing authorities. Excellent. Really good. I'm going to read that again, guys. It's so good. The Supreme Court's reliance upon a almost 100-year-old Supreme Court of Tennessee opinion, which has never been cited in any published federal court decision, is unpersuasive in light of the foregoing authorities. Good job, defense team. You know, screw you, SJC. That's what it says. It's like in your face. The SJC is citing a case that is 90 years old, and not even the federal court even relies on that case. Okay, continuing with footnote 11. Clark did not foreclose the success of the double jeopardy claim at issue. In fact, it expressly, quote, reserved, end quote, such claim, observing, quote, should the petitioner be again arraigned, the learned trial judge, if convinced that in truth and in fact all 12 of the jurors on this trial did agree and continued to the end of their deliberations to agree that petitioner was innocent, and that they failed to so report only because of a mistaken conception of their authority in the matter, may well conceive it his duty to exercise the right vested in him of advising the entry of, we gotta go all the way down to the next page, a nolle prosequi.
Nolli prosequi.
I totally mispronounced it.
Nolli prosequi.
Nolli prosequi, and according to DuckDuckGo, it means a declaration that the plaintiff in a civil case or the prosecutor in a criminal case will drop prosecution of all or part of a suit or indictment. So to reread that last bit right here, and that they failed to so report only because of a mistaken conception of their authority in the matter, may well conceive it his duty to exercise the right vested in him of advising the entry of nolli prosequi. Cool. Okay. It's solid, guys. Very impressive. Martin Weinberg, I believe he wrote this. Good job, dude. Okay, continuing, we are on page 27. It reads, under the SJC's reasoning, affidavits executed by all 12 jurors attesting to a final unanimous decision to acquit would not be sufficient to mount a successful double jeopardy challenge. Surely that cannot be the law. Indeed, it must not be the law. And in the context of this highly publicized case, it strains credulity to suggest that if the unequivocal statements of the 5 jurors quoted above did not in fact represent the unanimous view of all 12, the remaining jurors would allow the inaccuracy to go uncorrected. Instead, they would predictably have notified the Commonwealth or the trial court of their own recollection. Here, to the contrary, the Commonwealth has received the exact same information as the defense regarding the jury's unanimous agreement to acquit Miss Reed on counts 1 and 3. Absolutely. And guys, if any of this sounds familiar, it's because, especially this part, double jeopardy challenge, surely that cannot be the law. Indeed, it must not be the law. These are arguments the defense team used in their motion to dismiss previously. And excellent arguments they are. And just like looking at this last sentence here, to the contrary, the Commonwealth has received the exact same information as the defense. And they don't care. They don't care. Like, where's the oversight? The Commonwealth, the prosecuting power in this entire case, is informed by the jury members that Karen Reed was actually acquitted. She was found not guilty of counts 1 and 3. And the prosecution shrugs. They shrug, not doing their jobs whatsoever because they are led by corruption. Continuing, the Supreme Court's decision in Bluford is not to the contrary, as it is factually distinguishable from the instant case. There, the foreperson had reported during deliberations that the jury, quote, was unanimous against, end quote, the charges of capital murder and first-degree murder, but split on manslaughter. The court sent the jury back to continue deliberations and, when the jury remained unable to reach a verdict, declared a mistrial. The Supreme Court rejected the defendant's argument that the double jeopardy clause prohibited re-prosecution for capital and first-degree murder. In doing so, the court relied heavily upon the lack of finality of the juror's report. Quote, the jury's deliberations had not yet concluded, end quote, and it, quote, went back to the jury room to deliberate further, end quote. Quote, the foreperson's report was not a final resolution of anything, end quote, and there was no indication at the conclusion of deliberations that, quote, it was still the case that all 12 jurors believed the defendant was not guilty of capital or first-degree murder, end quote. Here, by contrast, the jurors' statements reflect a final and indelible determination that persisted through the end of deliberations and following, pulling away 1,000%. Excellent. I need to read it again. Here, by contrast, the jurors' statements reflect a final and indelible determination that persisted through the end of deliberations and following. Yes, guys. The jury members maintained, even after Judge Bev declared the mistrial, they maintained that Karen Reed was found not guilty of counts 1 and 3. And so we're on page 28. The defense respectfully submits that this court should hold that Miss Reed may not be forced to stand trial a second time for an offense a previous jury found her not guilty of simply because such final unanimous agreement was not announced in open court. Any lack of formality does not supersede the defendant's fundamental constitutional protections. I'm going to read that again. Any lack of formality does not supersede the defendant's fundamental constitutional protections. Amen. Provides a case law, United States versus Dotson, in parentheses, affirming correction of verdict on one count after, quote, receiving a telephone call from two of the jurors stating that contrary to the verdict read in court, the jury had unanimously voted to acquit, end quote. Excellent case law right here, guys. Excellent case law. I'm going to read it again. Quote, receiving a telephone call from two of the jurors stating that contrary to the verdict read in court, the jury had unanimously voted to acquit. They had unanimously voted to acquit, end quote. Okay, continuing. Vacated in part on other grounds. United States versus Stauffer. In parentheses, affirming changing verdict on count where, quote, post-verdict interviews of several jurors determined that the jury had intended to acquit, end quote. This issue is one of existential importance, not merely to Miss Reed, but to the very foundation of the constitutional safeguards that protect her. So you see, guys, the defense just cited case law in which post-trial inquiries involving jury members are absolutely taken into consideration. Meaning, Judge Bev is lying, and the Supreme Court is also lying. Continuing, letter E. Alternatively, the defense is entitled to a post-verdict judicial inquiry to determine whether the evidence supports the juror representations as to having acquitted Miss Reed. The SJC narrowly construed the right to a post-trial judicial inquiry to substantiate a constitutional violation as limited to claims, quote, that jurors were exposed to extraneous information or demonstrated racial or ethnic bias, end quote. Under this logic, no defendant claiming that the jury acquitted her but failed to announce that verdict would be entitled to further inquiry, no matter how clear and well supported her claim. In other words, even if all 12 jurors submitted affidavits saying they unanimously and finally agreed to acquit the defendant, their failure to announce that verdict and the trial court's failure to inquire would take precedence over the defendant's fundamental constitutional protection against double jeopardy. The defense respectfully submits that this ruling violates Miss Reed's constitutional rights. That last paragraph, guys, that last paragraph was so succinct and so on point to what the defense team has been trying to argue for the last several months since the last trial, since the first trial, since the declaration of the mistrial. They're saying, like, because even the Supreme Court agreed. The Supreme Court said there can't be any post-trial inquiries unless there's bias. Jury bias is proven, you know. But they are incorrect, again, as even the ACLUM provided case law in their amicus brief, proving that post-trial inquiries involving jury members happen in Massachusetts. It's not unheard of. Yep. Such a great paragraph. Good job, defense team. Continuing, in the analogs context of juror bias, the law is clear that the defendant's Sixth Amendment right to an impartial jury also guarantees, quote, the opportunity to prove, end quote, a claim of bias. Dennis versus United States. In parentheses, quote, this court has long held that the remedy for allegations of juror partiality is a hearing in which the defendant has the opportunity to prove actual bias, end quote. Thus, quote, a non-frivolous claim of jury taint, end quote, triggers the trial court's, quote, unflagging duty to adequately probe, end quote, the allegation. United States versus Zinni. Excellent citation. Crucially, the trial court, quote, does not have discretion to refuse to conduct any inquiry at all, end quote, when, quote, confronted with a colorable claim of juror misconduct, end quote. The required inquiry may include the taking of jury testimony, because a categorical bar of such testimony on the issue of bias would, quote, violate the plainest principles of justice, end quote. United States versus Viller. Recently, in United States versus Sarnave, 2024, First Circuit Court 2024, the First Circuit remanded the matter for further proceedings in the Boston Marathon bombing case due to number two, jurors' postings on social media, quote, regarding the bombings and the district court proceedings, end quote, which came to light after the jurors had been previously selected to serve. The comments did not reflect racial bias in any way, but rather possible bias specific to the defendant. Excellent citation. The comments were also inconsistent with the jurors' assurances that they had not discussed the case online. The First Circuit held that the district court erred by failing to inquire about these issues with the jurors. Given that, quote, the right to an impartial jury is constitutional bedrock, when there is a plausible claim that a prospective juror lied in a manner that may reveal bias, a court need conduct some inquiry reasonably calculated to determine whether the prospective juror did lie, and if so, why, end quote. Although the district court has broad discretion to determine the type of investigation into juror bias warranted by particular facts, quote, notwithstanding this broad discretion, a district judge does not have discretion to refuse to conduct an inquiry at all regarding the magnitude of the taint-producing event and the extent of the resulting prejudice, if confronted with a colorable claim of juror misconduct, end quote. Crucially, for present purposes, the First Circuit ordered the district court to voir dire the jurors 9 years after the trial. In doing so, the court acknowledged, quote, no doubt any juror would have strong incentives to avoid admitting having committed perjury during voir dire. We also respect that most jurors, having taken time out of their daily lives to receive evidence at trial, deliberate with other jurors, and reach a verdict that they believe is just, would prefer not to have that verdict disturbed, especially as a result of their own actions. We have no doubt that the able district court judge can do what judges regularly do, form a considered opinion about the sufficiency of the jurors' explanations once those explanations are given and explored, end quote. Pulling away, excellent citation. Excellent example of what has happened when a post jury inquiry was provided and ordered. And 9 years after the fact, guys. Amazing. Continuing. A post-verdict inquiry is similarly required to investigate claims of external influence. In Renner versus United States, quote, after the jury had returned its verdict, the petitioner learned for the first time that during the trial, a person unnamed had communicated with a certain juror, who afterwards became the jury foreman, and remarked to him that he could profit by bringing in a verdict favorable to the petitioner, end quote. The court, without the defense's knowledge, then enlisted the FBI to investigate. The Supreme Court held that the defendant was entitled to post-verdict inquiry regarding the FBI's unauthorized contact with jurors. So we are on page 31, guys, almost done with the memorandum. The defense respectfully submits that no less than a conviction rendered by a biased jury or impermissibly tainted by external influence, requiring a defendant to stand trial for murder after a unanimous jury found her not guilty of that same offense, would violate, quote, the plainest principles of justice, end quote. And they're citing the Viller case. There's a footnote here, number 12. I will read it when we get to the bottom. It continues, indeed, the SJC did not suggest otherwise. Instead, it erected an artificial dividing line between the Fifth Amendment protection against double jeopardy and the Sixth Amendment right to an impartial jury. Wow. I will read that sentence again, guys. The defense is throwing punches, and I love it. It reads, indeed, the Supreme Court did not suggest otherwise. Instead, it erected an artificial dividing line between the Fifth and Sixth Amendments. Good job, defense team, calling the Supreme Court out on their bias, on their corruption. Continuing. The defense respectfully submits that this result is not supported by precedent or logic. Excellent. They're still throwing punches. The defense is saying, guys, they're saying that the Supreme Court has no precedent. There's no case there and no logic, apparently, for that opinion, the artificial dividing line between the Fifth and Sixth Amendments. Oh, great job, defense team. Continuing. While the foregoing authorities arose in different contexts, they stand for the proposition that a defendant who comes forward with credible evidence of a serious constitutional violation post-trial must be entitled to an opportunity to prove those claims. Continuing, there is no apparent reason to artificially limit the availability of such constitutional inquiry, as the Supreme Court did, to racial bias and extraneous influence. The defense acknowledges that there is little precedent involving situations factually similar to that at issue here. This case is unique. It is not often the case that after trial, 4 jurors directly contact defense counsel stating in no uncertain terms that the jury had acquitted the defendant, but the unique strength of the evidence underlying the defense motion to dismiss supports rather than undermines the claim for relief. Absolutely. Pulling away. Excellent wording. But the unique strength of the evidence underlying the defense's motion to dismiss supports rather than undermines the claim for relief. Yes, the defense has everything they need. It is 1000% supportive for the claim that Karen Read deserves and has a right to relief. And as I said in videos a long time ago, guys, Judge Bev had every right to create new case law if she wanted to. The Supreme Court in Suffolk County had every right to create new case law if they wanted to, and they chose not to. And now the federal court, the district court in Boston, which is where I believe Karen Read's hearing will be held, they too have every right to create new case law from this case, this unique case in which multiple jury members reached out to the defense team and to the prosecution to tell them that Karen Read is innocent. She's not guilty, you know? And guys, what a profound thing that will be. I just got goosebumps. You know, Karen Read, if you've listened to her recent interviews, she continues to say that she feels this is her purpose. Like, her purpose was not to be a financial analyst, you know, that this is actually her purpose. To be a beacon of change, you know. And what a profound thing it would be if indeed the federal court next Wednesday, or at some point during the proceedings of the habeas corpus. If the district court creates new case law from the Massachusetts versus Karen Reed case, and in creating that new case law, it will ensure the safety of future defendants in the state of Massachusetts and everywhere else. Because at the federal level, it applies to all federal cases. So profound that would be, you know? And the way Karen Reed talks about it is as if, you know, she's speaking about it intuitively. Continuing, there's a footnote here, number 12. The decades-old Florida and Pennsylvania state court opinions cited by the SJC involved post-trial rendering of guilty verdicts, not acquittals, and are therefore inapposite. Provides a case law, Brown versus State, Commonwealth versus Johnson. Excellent. And what the defense is saying with this footnote is that the SJC, the Supreme Court of Suffolk County, cited case law in which there were guilty verdicts. But in Karen Reed's case, there were no guilty verdicts. So the case law that the Supreme Court cited is inapplicable. You know, this is again, guys, I've argued, I've vented about the Supreme Court in Suffolk County. They are wasting everyone's tax dollars. Those judges are not doing their jobs. They should all be under review. Continuing. Contrary to the SJC's characterization, the defense request did not seek to, quote, probe the content of juror deliberations, end quote. Yes. Again, guys, and isn't it funny, pulling away, isn't it crazy that the Supreme Court's characterization is Judge Beverly Cannoni's exact characterization, and it's the exact characterization that the prosecution had? That whenever the defense is saying, can we please ask the jury what their verdicts were? The prosecution and Judge Bev and the Supreme Court all have the same exact characterization, that by asking the jury members about the results of their deliberations, about the verdicts from their deliberations, it would be going into the contents of their deliberations, which is a complete mischaracterization. It is not actually what the defense team is asking. Continuing. To the contrary, the requested inquiry was directed solely to the result of such deliberations. Yes! It's the result. Like, how dare the prosecution and Judge Bev and the Supreme Court try to create new language? You know? They're trying to create new language. Like, again, the result is not the same as the process. It's not the same. There's the result, and then there's the process. The deliberations is the process. The verdict is the result. And the defense has, since day one, since the day they filed for dismissal, post-trial, they have asked for the result, not the process. Those fuckers, you know, all of them, the Commonwealth, Judge Bev, and the SJC, you know, all dicks. Continuing. Continuing, guys. Oh, I get so angry. Okay. Continuing. The result of such deliberations, namely, a unanimous decision that Miss Reed is not guilty of murder in the second degree. Juror testimony on that subject is not prohibited. United States versus Berrigan, Cepeda. Continuing. Quote in parentheses, Rule 606B bars the admission of juror testimony only upon an inquiry into the validity of a verdict. It does not limit the admissibility of juror affidavits to determine what issues were decided in a prior proceeding, end quote. Excellent citation from the defense. Continuing, in any event, evidentiary rules cannot extinguish a criminal defendant's fundamental constitutional rights. They're citing the case law Viller. Continuing, the inquiry requested by the defense here could be accomplished by a single, quote, yes, end quote, or, quote, no, end quote, question posed to jurors. Did you unanimously acquit Karen Reed of the charges in counts 1 and 3? Or similar questions that do not intrude into the heart of jury deliberations. And guys, pulling away, I argued this in a long time ago in a video. And as I said in part 3, it's like great minds think alike. I argued this before I read it from the defense, that it's a simple yes or no question, with a yes or no answer. And with that yes or no answer, they would have the result without going into the deliberations. Again, Judge Bev wanted to make this all seem like it was impossible. The prosecution, Michael Morrissey's office, everyone in there wanted to make this seem like it was all impossible. The Supreme Court wanted to make this seem like it was all impossible. Continuing. Of course, the results of a jury deliberations are not secret. They are, in fact, routinely announced in open court. Here, the defense learned post-trial that the jury reached a verdict that was not announced. It was at least entitled to the opportunity to substantiate that fact in order to ensure Miss Reed is not unconstitutionally forced to stand trial for criminal offenses of which she has already been acquitted. Such inquiry in no way intrudes on the deliberative process of the jury. Such an inquiry instead honors the jury service, which the trial court described as, quote, extraordinary, end quote, rather than disregarding the efforts of 5 jurors to disclose that there was not an, quote, impasse on all 3 as contrasted to only 1 count. Beautiful. So succinct, guys. It is beautiful. They threw Judge Bev's word back at her face. Such an inquiry instead honors the jury service, which Judge Bev described as extraordinary, rather than ignoring the efforts of the 5 jurors. Excellent. I just love this defense team. Continuing. The trial court rejected the defense's repeated requests to order a post-trial voir dire of the jury, where the court could make inquiries that matched what would have occurred if the jury was polled count by count, which Massachusetts Rules of Criminal Procedure 27 permits, if not prescribes, a voir dire that could be structured by this court or the experienced trial court to steer clear of overstepping the boundaries set by Massachusetts Guide of Evidence. Continuing, that could ask about the results of a jury's deliberations without asking about how the jury internally and secretly reached that result. Yes, they are cementing their argument repeatedly with different wording, that the result is not the same as the process, and all they've ever asked for is the result. Judge Bev can keep her process, you can keep the jury deliberations all to yourself. The defense doesn't want it. They just want the verdicts. Continuing, we are on page 33. The First Circuit has entrusted post-trial jury inquiries to the skill and experience of the trial court in matters ranging from extraneous influence to the intrusion of racial or ethnic bias during deliberations. The defense submits that the values at the core of the double jeopardy clause, the primacy of a jury's decision making as a protection for accused citizens against the perils of being prosecuted twice for the same offense for which a prior jury acquitted, is as central to the values of our criminal justice system as is the right to a trial before an impartial and unbiased jury. The defendant has met her burden of production. Far lesser showings, statements by one juror, for instance, have resulted in repeated holdings that jury inquiries are mandated. Excellent. So what the defense is saying, and they cite United States versus Tahita, the defense is saying in the sentence is Karen Reed met her burden of production. Far lesser showings, statements by one juror, for instance, have resulted in repeated holdings that jury inquiries are mandated. You see, they're saying Karen Reed met her burden of production between the case law and what actually occurred with the affidavits and the jury members coming to the prosecution and to the defense. And again, the attorney affidavits, it's all more than sufficient. It's all more than enough for a post-trial inquiry. So Karen Reed has more than met her burden in arguing her right to a post-trial inquiry. And the defense is saying that there were post-trial inquiries held for matters that had far less argument than Karen Reed. You know, far less damning evidence than Karen Reed does. Continuing. Again, guys, the Supreme Court is not doing their job. The Supreme Court did not do a damn thing. They hardly lifted a finger. Continuing. To create an impenetrable procedural wall to this new evidence just because a jury failed to volunteer to the court that its impasse was not as to all counts, just because it was never asked, is no more principled than to create a similar wall against new evidence of untruthfulness by a juror as in Sarnave, of racial bias as in Viller, of contact with an outsider as in Remmer. In each case, the jury could have been polled about outside influence or violating the court's rules by accessing the internet. But that clearly does not result in an absolute prohibition against further fact-finding on a showing far less compelling than that at issue here. Yes, excellent sentence. Like, they're, boom, citing all these case laws. Sarnave, boom. Viller, boom. Remmer, boom. And that within all those case laws, they had far less argument, compelling argument than Karen Reed has. Karen Reed has far more compelling argument than all that case law. There's no reason for Judge Bev to have denied the motion for a post-trial inquiry or the motion to dismiss, and there is no reason for the Supreme Court to have denied, to have affirmed what Judge Bev decided at the Superior Court level. No reason. Continuing. As in Sarnave, the law trusts trial courts to determine whether any of the jurors' answers to voir dire have been affected by media exposure. There cannot be one set of rules for trials and with publicity Sorry, I'm going to read that again. There cannot be one set of rules for trials with publicity and another for trials without it. Awesome. Continuing, the defense respectfully submits that confidence in the courts is eroded by the creation of such an impenetrable wall, preventing jurors from informing the judge whether they voted as a final matter to acquit a defendant of murder at a time that public confidence in the judiciary is pivotal, not allowing the jurors to be heard on a matter of such significance and allowing the trial court to decide without taking any action to ascertain the truth of the matter, if there was in fact a final unanimous unreconsidered decision to acquit, is inconsistent with the elevated role that jurors have long held in our democracy. That gave me chills. That entire last sentence gave me chills. So well worded. Good job, defense team. Roman numeral 5, conclusion. For all the foregoing reasons, the defense respectfully requests that this court issue a writ of habeas corpus and hold that Miss Reed's retrial on counts 1 and 3 would violate her double jeopardy rights. Respectfully submitted, Karen Reed, by her attorneys, Martin G. Weinberg and Michael Pabian. Awesome. So this was solely Martin G. Weinberg and Michael Pabian. Excellent work, gentlemen. Excellent work throwing the bias and the corruption back at Judge Bev and the Supreme Court. And Alan Jackson and David Unetti. Awesome. I should have kept scrolling. So this entire memorandum in support of the petition for habeas corpus, writ of habeas corpus, was put together by Martin Weinberg, Michael Pabian, Alan Jackson, and David Unetti. Excellent work. And certificate of service, I, Martin G. Weinberg, hereby certify that on this date, February 18, 2025, a copy of the foregoing document, the petition, and all exhibits has been served via hand delivery on the Massachusetts office of the Attorney General and via email on Assistant District Attorney Caleb Schillinger. Signed, Martin G. Weinberg. Excellent. So, wonderful work by the defense. And that's the end, guys. And then the next documents are the appendix. It reads Commonwealth Appellee versus Karen Reed, Appellant, on appeal from reservation and report, GLC to 11 subsection 3 petition. So again, as it continues, it is over 700 pages long. And I won't be able to read that before next Wednesday, but I will leave a link in the description below to this entire document if you would like to read it yourselves. I am so looking forward to the hearing. Again, I may or may not be in attendance next Wednesday. I will keep you all posted. But I've got so much faith in Karen Reed, in her defense team. They are solid. And I am praying that the district court actually does something. You know, they will be the only court to have done something. And again, this could be new case law that will change things for everyone else in this country at the federal level, at the state and the federal level. You know, we need something, guys. We need something to combat against the corruption in a way that ensures the corruption does not have an opportunity to do this again. Thank you all for being here, and thank you all for watching.